like me to do your screen share for you? I'm happy to do it. I have it set up now.
Yeah, sure. Why don't we go back?
Okay.
And then Dwayne, shall I just kind of let you know when we're ready to switch slides?
Yeah, if you want, I can just play it by ear. But yeah, you can just give me a hand signal or something, and I will advance it for you as needed. Okay. Um, so, welcome. Thank you for joining us today. Uh, we are going to examine the complex question of Canada's colonial past, the big past, and in particular how this history continues to affect Indigenous peoples. The Quebec Anglophone Heritage Network, which turns 20 this year, was founded by community museums and history societies around a commitment to help preserve and promote historical knowledge. We do that by building up people's natural curiosity to know about the places where they live and how they fit into the broader scheme of history. When we wrap up in an hour or so, my hope is that we can take what we learn back into our own communities and be inspired to regard them somewhat differently, to see the towns and cities and farmlands that we think of as part of Quebec and Canada, not just as the result of 4 centuries of development and land settlement, but also as places with a much older and deeper connection to the human story on this continent. Land and the laws that govern its use have shaped Canada's relations with Indigenous peoples since the start of European settlement. But colonial law and the history through which these relations evolved have for the most part left out or marginalized Indigenous peoples with whom we share this country today. Today, unless a protest makes headlines in the news, we are never asked to reconcile the history we learned in school with the ongoing struggle of First Nations, Métis, and Inuit to defend and advance their inherent rights. If Canadians are sincere about reconciliation, as I believe most of us are, then I think we have a responsibility as educators to be part of that process. First Nations reserve lands today account for 0.2% of the land mass that falls within Canadian borders, which means that 99.8% of all the territory that belonged to Indigenous peoples before my ancestors settled here is now claimed by Canada. By what course of past events did this transfer happen? Modern land claims can reflect this history, which I think it's fair to say most of us, certainly of my generation, were not taught in school. I did not learn about broken promises, breaches of territorial and title rights by past governments, forced relocations, the Indian Act and its establishment of the reserve system, the Indian residential school system, or any other policies and practices which have shaped Indigenous history for the last 200 years. Kate Gunn has kindly agreed to join us this afternoon to discuss some of the legal, ethical, and practical issues that surround this history and the question of Aboriginal title and rights in the 21st century. Kate works with First Peoples Law, a firm based in Vancouver. Kate, welcome, and thank you for agreeing to speak with our group. I turn it over to you.
Great, thanks so much, Dwayne. Yeah, it's great to be able to speak with you all today, and I guess it's been one of the sort of side benefits of the pandemic that although we're not able to have conferences and in-person meetings, that it is sometimes a little bit easier to connect with people via Zoom. So I'm glad to have that opportunity. My thought today was to give just a brief introduction and a little bit of a framework about the legal landscape in Canada around Aboriginal title rights and treaty rights, but then really to leave time to have just a discussion about what that means for all of us and to try to answer questions or talk through any issues that might be on your minds at this time. With the two disclaimers, I think that are one, that I'm not a historian, and two, that although our work for Indigenous communities goes more or less coast to coast, that we don't, as far as I'm aware, we don't have work with any communities right now in Quebec. And so my Quebec specific knowledge is not significant, let's say. So I'll be keeping most of my comments on a kind of more general level rather than a Quebec specific level. So with that, I guess brief introduction, just in terms of who I am. I am a lawyer who's been working in the field of Indigenous rights for about the last 10 years. I'm based in Vancouver. I am of settler heritage. My family originally came from Scotland and moved to Ontario and then out here to Vancouver. I grew up on a small island off the west coast of BC. And I have been working at First Peoples Law since it started, or more or less since it started. And our goal is to work with Indigenous communities to help them advance and realize and implement their title rights and treaty rights. And as part of that, to support them in their efforts to protect and benefit from their ancestral lands. And so we do a lot of different types of work for different communities, but I think that's the kind of main connection and focal point is that nexus of inherent rights and seeking to protect and maintain a connection to ancestral lands. And so I think with that, Dwayne, if you could just flip the slide forward one. I put together a couple of slides, not because I think it's important necessarily for anybody to have a takeaway of the particular words here, but just to provide a bit of a framework for our conversation and hopefully help with some of the questions later. The things that I wanted to touch on briefly today are just the basis of what we mean when we talk about Aboriginal title rights and treaty rights and the kind of obligations that the Crown has. And when I'm talking about the Crown in this context, I mean both the federal and provincial Crown in relation to those rights. And then from there to talk and think a bit more about what the concept of reconciliation means when we're looking at and considering those kind of rights. And I also wanted to touch on the concept of the Section 35 of the Constitution Act. Because I think it's, we hear a lot in the media and the news about just talking about rights, different types of rights. And, you know, we have in Canada, there's rights under the Charter, there's different forms. And so I think that it's important to take a look at these ones in particular. And so when we talk about rights and we're talking about Aboriginal people's title rights, treaty rights, one of the key things to keep in mind is that the rights that exist and are protected under the Constitution are also not defined. So that aspect of the Constitution has been left completely open to interpretation, as are the Crown obligations that flow from the recognition and protection of rights. And so a lot of the conflict and discussions, negotiations, and some of the litigation that we're involved with as well is really focused around one, defining what those rights mean, like whether it's a right to hunt or a right to own land or any number of things, what those are. And then in addition to that, what does that obligate the Crown and also us as settlers and people living on lands that were and are occupied by Indigenous people? What does that obligate us to do in terms of protecting those rights? So Dwayne, can you switch to the next slide? So I think the underlying purpose of Section 35 is simply just to recognize that First Nations, Indigenous peoples existed and were present in the land and organized societies, exercising their own laws long before Europeans arrived, which I think in this sort of time of reconciliation seems probably quite clear to everybody, but at least in terms of how Canadian courts approached it until even relatively recently was not something that was always accepted or acknowledged. And then the other piece of that is that prior use and occupation of those lands gave rise to rights that are recognized both at the time in international law and by the Crown. And so for when we talk about rights, sorry, thanks, Jay. The purpose of them is basically to recognize and protect those rights, and also to seek to reconcile the rights and interests of Indigenous people with what Canadian courts have described as the assertion or the de facto assertion of Crown sovereignty. And I think from our perspective, it opens up a lot of very interesting and nuanced questions around what reconciliation means. If there's the assertion of Crown sovereignty, there's settlers living on lands, but there are pre-existing rights, and the way those rights are intended to coexist has not been resolved, both on a legal level and also just on a practical level. Next slide, please. There are a couple different types of rights that we talk about. The one category is Aboriginal rights. And I think I should also note that sometimes there's an overlap in terminology where you'll hear about Indigenous rights. And at least from my perspective, I see that Aboriginal rights, as it appears in the Constitution, it's really Canadian law as it applies to Indigenous people, as opposed to the legal systems and laws of Indigenous people themselves. And so while we in our firm and people work to try to support Indigenous people in exercising their own laws, it's not the same as a right recognized under Canadian law. So the Aboriginal rights that we're talking about with the Constitution are the inherent rights that flow from the continued use and occupation of those lands before European contact and the assertion of Crown sovereignty, held by a collective group. And for the purpose of Section 35, it also includes Aboriginal titles. So that would be the right to own and use and benefit and make decisions from ancestral lands. Next slide, please. And then the other subset of rights that are important from our perspective are the treaty rights, which are those rights that flow from treaties between Indigenous peoples and the Crown. And that can be both the historic treaties, so treaties that were entered into prior to or around the time of Confederation, as well as the more modern treaties, which we sometimes hear referred to as land claims or comprehensive claims, so agreements between Indigenous peoples and the Crown that are intended to address and resolve outstanding issues around historical rights to land and governance issues. Critically, I think, is in particular for the historic treaties, Indigenous peoples and the Crown have very different interpretations of those treaty relationships and what the agreements were. We have worked with communities as far east as New Brunswick, and then quite a few communities in Ontario and the Prairie provinces. And I think unanimously, what we hear is that Indigenous peoples' oral history supports the view that the treaties were about an agreement to peacefully share and coexist on lands, not to surrender the right to make decisions or to surrender the ownership of those lands. And the Crown and Canadian courts have proceeded on a very different path, largely focused on the idea that the treaties are confined to the written English, usually text, and amount largely to land surrender documents. We have seen in the past couple of years a beginning shift in the courts towards more willingness to look at Indigenous views to the treaties, and it's a very slow type of legal process. So I'm not sure how quickly we can look to seeing more positive decisions, but there does seem to be a bit of a shift towards acknowledging the Indigenous perspective on those treaties. Dwayne, can you touch? And this is, I think, my last slide on just the concept of Section 35 rights that I wanted to touch on, which is that when we talk about Aboriginal rights, because they exist and they arose prior to the arrival of Europeans, although Canadian law might recognize them under Section 35, it doesn't mean that they don't exist just because the Crown or courts don't recognize them. And so we have cases now that require that the Crown consult with Indigenous peoples even before a right is established or recognized. The case that really, I think, articulated this was brought by the Haida Nation here in BC. In that case, they had, I think by all accounts, a very strong claim to Aboriginal title for their territory because they've used and occupied a particular island from time immemorial, but Crown hasn't recognized that title yet. And so in the case that gave rise to the concept of this requirement to consult, the provincial government had authorized a company to log a particular type of tree that was really important to the Haida, both culturally, but also to use as evidence to establish that they did hold title. And the court said that, you know, if we're going to be serious about reconciliation, there are obligations on the Crown to consult with Indigenous people and make changes about decisions or activities that are authorized on their lands, even before those rights are established or recognized by the Crown or courts. So when we hear about the duty to consult, which is something that I think also comes up frequently in the media, that's generally what it's talking about, is that obligation to talk to and work with Indigenous peoples before making a decision that affects rights, both that are already established and ones that are not yet proven. Dwayne, can you switch slides, please? And so before shifting to trying to address any questions that you all may have, I wanted to give one example of the type of work that we do and some of the issues that we've been trying to grapple with lately. And the one that I wanted to speak about briefly is around the Wet'suwet'en, largely because it's an issue that I think has gathered, at least pre-COVID, a lot of media attention, both within BC and in other parts of the country. And also because it really highlights some of the unresolved issues around reconciliation. So we represent one of the house groups within the Wet'suwet'en. The Wet'suwet'en are an Indigenous nation in north central British Columbia. We represent Unistoten as part of the Wet'suwet'en. They are the house group within the Wet'suwet'en that operate a healing center on the land, which is designed to help people, Wet'suwet'en and other Indigenous peoples who are recovering from intergenerational trauma and the related effects of residential schools, to be out on the land and to be able to heal through land-based and cultural practices. And so the Coastal GasLink pipeline project and the conflict that surrounds that has been ongoing for a long time, but came to a head both last 2 winters ago and then just this past winter, in both cases because the provincial government authorized Coastal GasLink to proceed with building a pipeline over the objections of Wet'suwet'en hereditary leaders and their supporters. The Wet'suwet'en have established a barrier that, like a physical barrier to prevent the company from accessing the territory, and are seeking to maintain that position based on Wet'suwet'en rather than Canadian law. And so there was, widespread media reports about RCMP enforcing that injunction and the solidarity actions that then happened across the country in support of them. And I think that the reason that it is significant for us to think about is that we often hear courts saying that Indigenous peoples have no veto over resource projects or decisions about their land. So they might have a right to be consulted, but at the end of the day, they don't have a right to just say no without a particular reason or justification. But in this particular case, the Wet'suwet'en had already been to court in a landmark Supreme Court of Canada case, where although they didn't get a declaration of Aboriginal title, they had provided significant amounts of evidence establishing their use and occupation of those lands. The court didn't ultimately grant them a declaration of title, in part because the law was still developing at that time and because of some issues in the way the arguments had been framed, and told the government to go back and negotiate with them. But bottom line is, government has a lot of evidence about what's so entitled to this land, hasn't resolved the issue. And at the same time, Canadian law hasn't resolved the question of what to do when Indigenous peoples who have title to lands take a hard no about a project, say that, or any kind of decision, like we just full stop don't want this happening on our lands. I think what we saw really is that this last winter came down to the RCMP enforcement rather than working it out either in negotiations or in court. So it's an outstanding live issue, and I just wanted to highlight it here as one of the pieces that we're actively looking at and thinking about. And then my last slide is really just, which Dwayne, you can switch to. Thanks. Is really just to transition into hopefully talking a little bit further with you all about reconciliation and just what it looks like to us, how it might be put into practice, and especially keeping in mind that underlying Section 35 rights. And I think it may be a little bit different for everybody, but I think for myself anyway, one of the key pieces of it is that I think, at least in the mainstream media and for some levels of government, there's a desire to perhaps skip some steps that in order to achieve reconciliation, we need to have a piece around recognition both of how we got here in a historical sense, and also around what needs to be done to make some of those wrongs right. And so some of that hard work of reconciliation, as opposed to a more feel-good approach. And so I think I'll close it there, just with thanks to Dwayne for manning the slides. And I would be happy to talk to anyone further about questions or issues or things that might be on your mind.
Thank you very much, Kate, for that introduction to the legal framework for the subject under discussion today. I'm going to take just a minute to ask everybody to unmute themselves if they have a question. If you're uncomfortable asking the question aloud over Zoom, you may also use the chat feature, which you'll find somewhere on your Zoom screen there, and write that question either to the group or to me or directly to Kate, which I think are the options you have in that function. You bear with me here, I'm new to this, but I believe you also have a function which allows you to raise your hand virtually if you would like to ask a question. But I'm going to begin with a question of my own right away for Kate, and it follows up on your last remarks about the responsibility of non-Indigenous communities to kind of take responsibility for or face their own history, the history of this country as one of colonialism. I'm going to ask if you think that this country needs to take Indigenous land claims seriously. There are those who point out that history cannot be undone, that our past is done, and this is the country that we deal with now. But why do you think it's important that Indigenous land claims be taken seriously by local historians, for instance, or historians in general? Is this part of our history? Are we living through a moment where history is in the making, so to speak?
Yeah, I think that's a good question. For me, the thing that I reflect on is that I think I and so many of us were raised, in my own elementary and high school education, and probably university as well prior to law school, really without any actual understanding of how history had unfolded for Indigenous peoples and the interactions between Indigenous peoples and settlers in my own community. And so I think that from a historical perspective, it's critical because we haven't really had that opportunity yet. And so I think a lot of us are really learning on the fly and trying to catch up. And then I think the other part of it is that it's not just history. For Indigenous people and Indigenous communities, these things, they arose in part as a result of past events, but it's an ongoing issue. And so the issue, for example, of land claims or Aboriginal title, it's not something that's just about, say, righting a historical wrong, but about addressing what's actually happening, just like with the Wet'suwet'en, for example, like out on the land right now. So yeah, both of historical importance, but also just in terms of reconciling who we are in this present moment.
Thank you. I see Kevin is here. Kevin Deere is an elder with the community of Ganawagi. And sorry for putting you on the spot, Kevin, but did you come on because you had a comment to make? I noticed that you turned your mic off. Did you want to step in here and perhaps make an observation about the importance of land to the traditional practices and heritage of Indigenous communities?
All right, that's fine. So I'm on right now.
Yeah, hi. Welcome.
Okay, so
Hey,
nyawa koneka takara ni wanage on the got ko we honto signore tana giru. Neka diwai chini to ayer ha honto signore tana no hotum teri watandi unutsi uka the hot ko we takara ni wanage sinekane kana wara dutsa. Agwego wat kuno wara dutsa nizu. So what the husadad one is rade. And a gwego atstets in a hot yun hedge now rio gwego sego kan either so one is rade kadinayotan and one. So anyway, so thank you. So in my own language, just to acknowledge all of us that are on this call, I'm deeply involved in our own confederacy, our politics. I was involved with Wet'suwet'en when they came down to Tigay and the Nega, and then I helped to caravan them when they came here to Ganawagi. So I was deeply involved with all of what unfolded there. I believe it was near the last week in February. Anyway, so it was referred to as, people put in an economic slowdown on Canada, and then Mother Earth decided, I'm going to show you how we do it. And then wherever this COVID-19 came from, doesn't matter. The thing is, it's here, and what's happening and what's unfolding. There was just a whale that came up here to the Mohawk territory that died the other day because it got hit by a ship. But there's things that are happening, and we got to be mindful of the bigger picture that is unfolding here. One of the things that I'm going to say right off is that I belong to a sovereign government, the Iroquois Confederacy. We made treaty with the Dutch, with the French, with the British, the 13 colonies, which became the United States, and then we have our own alliances with all of the other natives here. When Trudeau patriated the Constitution, and when that came back, 1982, and some of those discussions that were beginning to go on and engage Native people, well, we have a different perspective on that. I'm going to show you a little picture right here. Can you see this picture okay?
yes.
Okay, so this is what we call in my language, Jonarattazet Goa. Jonarattazet Goa is the great tree, but then from the great tree comes that now what we call Kajokwan Huxtu. So the great tree, what holds all of the people together, and we refer to that as our constitution. Now, for the life of me, there is no foreign government that can come to this land and ever supersede our constitution. The next thing we always talk about is relationship. We're in relationship with all the settlers, all the foreign governments, and as far as we are concerned, the Confederacy, our rights does not come from Section 35(1) or what have you. It never has and never will, because that again is us getting sucked up into this where the colonizers set the parameters, they set the game, And all we are as pawns being used again with the idea that they gave us something. So, and I know there's some people that will argue to the contrary with me of our own people because we don't see, but we have a whole different history. And all I'm saying is that that's all right. You people, some people feel that it once has to be entrenched. That's fine. But me as a sovereign government, mine comes from our ancestors, from the creator, from my language, from my culture. And in my language, there's no such thing as land claim. You know, we call this, and even like, I'll just give a little example. If I say I want something in my language, I would say, Dewa gato hunzoni. Hunza is the word that we have for the earth. It means that everything that I will ever need comes from the unconditional love that the Earth Mother gives us all the time. Our responsibility to that is we're lucky that today we still have our sacred ceremonies, song, dances, speeches, and rituals, because in our creation story, when our ancestors were made, which means that we are spiritual people that have this physical experience that this body allows us to express this. But our that word means that we have spirit life forever. When we take that whole word apart, unwe means forever. Unwe means that we're people with a spirit forever. So when we fully understand who we are, you know, the peacemaker, because prior to European contact, we'll be honest, there was wars and there's things that went on because our people's minds went a certain way. Peacemaker came and he has reestablished that, and he says it's one dish with one spoon. All of us, 5 nations, Mohawks, Oneidas, Onondaga, and Seneca, we all have co-equal right now to these lands in question. There's no more territorial boundaries. And if you want to be a chief, a leader, you are the last one to eat because you're in servitude to your people. Now that's been hijacked by the ruling elites, by capitalism. Now we have the rich against the poor. But you know what? This idea, one dish with one spoon, is supposed to apply for the entire world. Because if we fully understood this concept, there would be no wars, there'd be no famine, there would be no billionaires and rich people because we would all prosper together. And now, you know, people are talking about all of this stuff again. And all we have to realize is that, you know, all of us are afforded equal. But at the same time, we have to understand that the animals, the water, and all of those things in the natural world, that they also have a voice. They have to be factored in. And it cannot always be that, you know, at the end of the day, as long as we make a profit, then we're good because look where it's taking us. Anyway, I'll stop there. Thank you for this opportunity.
Kevin, thank you very much for those comments. Sounds like you've got an article in you. I'm still waiting for that article for Quebec Heritage News. Sounds like a good one. All right. I have a question from Dr. Kathy Martin. She is from the Mi'kmaq community of Listagouche, and she writes, in reference to duty to consent, can claims be made against various organizations or governments that have not properly conducted informed consent for projects? Is there even a process for properly attaining informed consent for projects on our traditional territories and or reserve lands? And I believe that question is certainly directed toward you, Kate. Can you respond?
Sure, yeah, thanks. And I guess I should also, Kevin, I really appreciated your comments because I think it's important for all of us to just, even while we're talking about these ideas about Section 35 rights and the Constitution, to keep in mind, as you say, that, you know, for people who are not settlers, that these rights are inherent. They don't require the Constitution to bring them into existence. And so when I'm talking about the Canadian law piece of it, it's very much what are the obligations on the Crown to address those, but not to look to Canadian law as though it's the source or source at all of the rights of Indigenous people. And then in terms of Kathy's question, I think the issue of consent is very much a live one. I think the Canadian courts have they've gone it's far enough to say that in cases where the Crown and courts recognize title, that the consent of an Indigenous group is required before, for example, a project can proceed. But the court also built in some loopholes around that about ways that government can try to justify a project, so that even where a group holds title and that title didn't recognize that, there's still ways that government could override opposition to that particular project or decision. One of the things that we're seeing more of, I think, is looking to some of the principles under international law, like the United Declaration of the Rights of Indigenous People and the right to free, prior, and informed consent. And here in BC, the provincial government also has enacted legislation that's intended to implement the declaration, that requires government in the province anyway to look at laws and find ways to bring it in line with that requirement of consent. So I think
I'm sorry, may I interject just a quote, because I actually have a section from the UNDRIP. I don't know if everybody's familiar with this, but this is to follow up on what you just commented on. It is the United Nations Declaration on the Rights of Indigenous Peoples, and this is what it actually states. It says, Indigenous peoples have the right to lands, territories, and resources which they have traditionally owned, occupied, and otherwise used or acquired. And Indigenous peoples have the right to own, use, develop, and control the lands, territories, and resources that they possess by reason of traditional ownership or other traditional occupation or use. Okay, that's just a very short section of it, but following on, I know what Kevin was saying, and what you were, I'm sorry, interjected your comments on, but where do we stand now in Canada vis-a-vis that? Has Canada adopted or begun to implement this declaration?
Yeah, so that was where I was going, Dwayne. So yeah, we have the federal government has agreed to, they've endorsed it, but because it is, it's a aspirational document, it doesn't have teeth on its own, they need to pass legislation federally and provincially implementing it. So the legislation that I was referring to that has been passed in BC, that's the intention, is that it's supposed to be provincial legislation that would bring provincial laws in line with the declaration. The federal government has said that they're going to, but they haven't done it yet. So right now we're left with a commitment to this in principle, but it is very difficult to get a meaningful, for example, court decision out of it until federal legislation is passed that reflects the principles in the declaration.
Thank you. Does anybody else have a question for our guest, Kate Gunn, at this moment? Or shall I continue peppering her with questions?
I have a question, Graham. I was wondering if you could comment on. Hi. If you could comment on the effect of the covenant chain intervention and the Wet'suwet'en.
You know, I don't think I can actually. I think the covenant chain for me goes more to issues of Indigenous law, and I don't know that I would be able to speak to that with any kind of accuracy.
So it's more of a real politic issue than a legal issue.
Yeah, still, I think my answer would probably still be the same. I'm not sure that, unless there's more context that I can try to speak to. Just in general, I'm not sure that I can address that with any kind of specificity.
Well, maybe Kevin could answer, because the covenant chain, I don't know, maybe an explanation of the covenant chain is warranted. I understand that the Wet'suwet'en joined the covenant chain. Kevin, is that correct?
Well, they request to have an alliance with us, and they were supposed to bring it to a Grand Council in Onondaga. But with my job, I just wasn't able to attend that meeting. But, you know, there's many nations that have come and formed these alliances because the Great Tree of Peace and everything that it embodies is talking about this whole unity of us all coming together, you know, and then the whole premise of all of that is that we become strong. And then the Two-Row Wampum Treaty Belt just says, what is this relationship going to be look like? And essentially it just says that whatever we do, because they came with God and Jesus, and we believe in our ancestors and the Creator, we said we're talking about that same sacred source that is the life source of all. So we shouldn't have a problem. So we smoked the peace pipe, but then what happened? It's all out of whack, it's out of kilter, and as a result, you know, we're always just given, you know, what I would say, like tokenism. You know, we're invited to certain things and all of that, but when it comes down to fully appreciating who we are, our language, our culture, and all of that, you know, they don't really want to do it because they think that you know, that they have too much to lose, that we're gonna take everything back and maybe send people back across the ocean. No, we said that with their ancestors that we would be as brothers and sisters, and we would share and cooperate, but it's still like this. You know, so we're working now, because I believe without a doubt that what is happening right now in this Turtle Island is the indigenous spiritual resurrection, that we are resurrecting up. And we're coming to a time where in our condolence ceremony, we have to help everybody that is here, and even our own people, to begin to start to see different, hear different, speak different, and we better start doing different, because global warming, climate change is real. And if we don't reestablish a sacred communion with our mother, the earth, the animals, the fishes, and everything that sustains us, well, then the people that believe that the economy should overrule the ecology, we're not going to be here very much longer, and we don't have very much time left. So it's imperative that the governments at all levels begin to engage in us, understand the indigenous knowledge and wisdom and teaching of this Turtle Island, and we better start getting with the program. And it all has to do with relationship and polishing that covenant chain, which essentially says, if I have a conflict with you, or you have a conflict with me, we don't bring our police forces, and we don't bring no standing army. We're pacifists. The peacemaker came, and Jesus says the same thing: love your enemy. So now we're supposed to use the power of love and a good mind and to resolve these issues, because no human being, I don't care what rationale they use to kill another human being, be it army, being a cop. And if we all understood this, all the wars stop immediately, all the rape stop immediately. We cannot steal, we engage from this peace, love, and we're able to have what they say, heaven on earth.
Thank you, Kevin. We have a couple of other questions coming in here. Kate, can you still hear us? Yes, great.
Yes.
This question comes from John Mackley. He is involved with the Barrie Historical Society here in the Eastern Townships. And John asks, Canadian citizens have no mechanism to influence court decisions. Can political pressure on elected officials and institutions be sufficient to bring about a recognition of pre-existing rights?
Yeah, I think it is a really good question, especially thinking about some of the outcomes around the Wet'suwet'en struggle this winter. I think that in general, court decisions they're useful and probably necessary in many ways, but I rarely think that any court decision on its own without corresponding political pressure is likely to be successful in terms of getting a positive outcome in the long run. And I think that one of the really positive things that I saw coming out of the Wet'suwet'en issue this winter was that non-Indigenous people who, perhaps up until now had not had a very fulsome understanding of issues around Indigenous sovereignty and rights, had become more educated, and as a result were willing to stand with Wet'suwet'en right across the country. And so I think that the political pressure piece is really important, especially as we all kind of collectively become more educated about both our past and the current state of affairs, because I think that that's part of holding government, like federal and provincial government, to account. And so I don't know that political pressure on its own is also sufficient, but I definitely think it's a really important part.
Mr. Mackley had a follow-up question, and I think it speaks to our group specifically, and some of the questions that our members are perhaps thinking of these days as they imagine their their own resources and strengths being brought to a reframing of our narrative, the stories we tell about the places we live. And John writes, what more can we as historical societies and individuals do to facilitate the education of what is absolutely the Indigenous story? I know there is not just one Indigenous story, but I appreciate the point of the question. How can we do a better job as historians and historical community relating this these perspectives that are not European or Eurocentric?
Mm-hmm. Yeah, and I guess it's a bit tricky to answer because I'm not sure what you're already doing, and I can tell even just by the fact of this Zoom session that there's obviously some engagement and an appetite to do this kind of stuff already. I think one really important thing is familiarity with the specific history that you're working with in the community to the extent that you can. And the other piece, I think, is around, whenever possible, trying to center and support Indigenous peoples telling their own stories, their own histories, and finding ways to, I guess, kind of shift the focus from some of the narratives that we've grown up with or that we might unwittingly perpetuate that are particularly Eurocentric. So by really bringing those Indigenous voices into the forefront.
I'd like to, again, I'm going to put David on the spot here for a moment, but we have with our group today, Mr. David Bernard, who is a historian from Odanak, which is a Wabanaki village at the mouth of the St. Francis River, where it enters the St. Lawrence. David has been working this winter with students of his on a project to relate the history and heritage of traditional ash basket weaving. An article on that subject will be appearing in a forthcoming issue of our magazine. David, perhaps that question about what we as historians can do in our communities to better relate the perspectives of Indigenous peoples would be better directed at you, since you work in that milieu. Would you like to comment, David? Oh, no, that's not David, but David, are you there?
Yeah, I'm here.
Hello.
Yeah.
Hi.
Could you clarify the question?
Yeah, I'll re-ask it. The general question is there a way for historical societies and Indigenous communities and the work they're doing in their communities to work together to do maybe exhibitions or articles or research projects together? Is there a way? Is that something that you have had any experience doing, or would you have an interest in doing? Speaking as a historian with a special interest in the Wabanaki history.
We had a project this year. It's called Abasinondali Onde. It's a project on basketry. And a lot of young people, they were participating in it. There were people from Hodanak, Wolinak, and from Pierreville, the French-Canadian village just aside. And it was really enriching to do those processes together and sharing the history of basketry together. And when you look at it more closely, you can see that people from Pierreville, people from Saint-François, they were also doing basketry during a certain period of time. So there is a lot of place like this that there is a share space. In other cases, it's more difficult because in Quebec, it's kind of hard to for people to admit the colonial situation of Quebec, like because of this double status of colonized and colonizer. But I think it's really important to do those kind of work of like confronting perspective, sharing perspective. Yeah. But I think it's a really hard work to do right now.
Yeah, well, let me just put in a plug for our network. We have a lot of small but vibrant little museums and historical societies who will be very eager to work with you and other Indigenous historians so that we can together start bringing a different perspective, a reconciled perspective. But I have another question, a couple of other questions that have come in on the chat line, so I'll just read them quickly. One comes from Judith, I think via Facebook, and the question is, what does self-government mean for Indigenous peoples living in a province or a country? I guess that question really is directed at our guest speaker, Kate. In a nutshell, can you define self-government for us legally?
Yeah, I can try. Yeah. So I think it's one of those questions that it comes down to the perspective of who's answering the question. I think that the idea of self-government or self-determination, if you asked the federal or provincial governments, it's probably something that's relatively limited, and that from the federal and provincial perspective often involves a sort of idea of giving away their jurisdiction or transferring it to an Indigenous community, almost the same as a municipality, which I think for most Indigenous communities is really not their vision of being self-governing and self-determining people. And so one of the possibilities that I think some folks are talking about is really exploring the idea of having multiple layers of legal authority on the land. So there might be multiple different Indigenous legal orders and laws, as well as the federal and provincial laws, and that one of the kind of really tricky things in terms of reconciliation would be figuring out how those different types of authorities work together in a way that both makes sense, but that also provides Indigenous people, like allows them to take care of their lands and their people in a way that's meaningful and isn't some sort of perpetuating the existing system under the Indian Act and the colonial status quo.
We're coming up to the end of our session now. I will ask one more time if there's anybody who would like to direct a question at our guest speaker, Kate Gunn, today. And I will await those questions, whether they come in by chat or otherwise. But I do have another question for you, Kate, while we're here. It's a very, very broad question, and I don't know if it's even possible to begin at addressing it in the context of a Zoom meeting, but what do you think it would mean to actually decolonize Canada? We hear that term decolonize and decolonization bandied about. It's always puzzled me what it actually means. What would it mean to decolonize Canada and our relations between ourselves and Indigenous peoples from a legal point of view?
Yeah, it's a huge question. I can't answer it, obviously, on the Zoom meeting. I think that, I guess, primarily I'd say it's probably not something where we know where we would end up. I think we know some places that we need to start. We need to start by grappling with our history and with our current reality and what that means in terms of our own kind of obligations to Indigenous people, knowing what we know or what we're coming to know. And from there, I think it's uncharted waters. And in terms of living in a country or a space that's actually decolonized would probably mean being open to addressing some very hard things, some things that we may need to give up or share that we're accustomed to taking for granted. But I think it would be a process that would need to be written together with Indigenous peoples. And so I don't know what that would look like in the end.
I want to thank you so much for being with us. Oh, I do have one last question. I'll try and sneak it in here. I'm not sure what happens to a Zoom meeting when your appointed time runs out, so I wouldn't want to be cut off abruptly. This question comes from Doug Brown. If there are competing federal, provincial, and Indigenous jurisdictions and legal claims or responsibilities, are there lands where there are competing Indigenous legal title and responsibility? I'm not sure. Are there lands where there are competing Indigenous legal title and responsibility?
As in, are there lands where more than one Indigenous community would hold authority over the same piece of land? Is that...
That's this. I don't know if you can hear me. That's the sort of thing I meant.
Yes.
And it can have to do with resource development in Alberta and things like that. The very complex thing you evoked of federal, provincial, and Indigenous jurisdictions somehow being active in some cases together. How are there processes by which competing or side-by-side Indigenous legal orders could be worked together, if that makes any sense?
Yeah, that does make sense. Yeah, so in BC in particular, where there's not a lot of treaties, we do see that a lot. There's significant amounts of areas where ancestral lands overlap with one another. Definitely in BC, we see both the provincial and federal governments using the fact that there are those overlapping jurisdictions as a bit of a perpetuation of a divide and conquer mentality of trying to sometimes pit different groups against one another. For example, like the provincial government might say, well, we're not going to settle this claim because there's this problem between two nations that don't agree whose land it is. From my perspective, those are issues that can and should be best addressed internally by Indigenous law, and it's not something that federal or provincial governments need to wade into or exacerbate, but we do see it happening, in particular with things like the BC Treaty Commission process.
That's great. Thank you very much, Kate. I think I'll end it here. Thanks to everybody who agreed to be with us today. And for those of you who agreed to speak when I put you on the spot, Kevin, thank you very much. David, thanks to you as well. Somebody asked if this conversation might continue when our Zoom meeting closes in a moment, and I certainly hope it does. Send me an email. I do have one thing to report. Most of you had signed up for our conference in October, the Indigenous Heritage Conference. I'm sorry to report that we have had to cancel it. We will be sending out refunds for your registration fees in the coming week. The military college where we were going to hold it has decided they cannot accommodate any public activities until the new year. And because we cannot keep rescheduling this, waiting for the COVID pandemic to pass, we've just simply decided to cancel it. However, I am working on getting our speakers to agree to sit in like Kate did today and give us the presentations electronically over Zoom. And I believe that we will have that program available to you, but conforming to a different format. So stay tuned. The conversation will continue, and I can always be reached at my email, one day by phone in the Quan office if I ever get back there. So thanks again, everybody, and I will say goodbye. Thank you.
All right. Bye, everyone.
Bye.
Bye.
Thank you very much. Bye-bye.
Thank you so much.
Thanks. Thank you.